Yes. So I'm asking this test away. What we did. They said they picked it up. Sure. And they said they said the last 5 minutes you have different rules. Yes. I don't know. But it was working fine. What are the people of this conversation? I don't know. I'm just realizing that it's unmuted. Although I've taken the volume down, so maybe it's. I asked her, she said she'd be up. Got something harder, it was hard books. Why did you give us books? Those books. But what was there? It doesn't matter. Give me two. The big ones. One happens this box. It's not so hard. Is it? There are a lot. Ladies, we are 5 minutes to going live. Good afternoon, ladies. We are 5 minutes to going live. I trust you are all settled in right now. Can you see me, Rahima? I can see you loud and clear. You look beautiful. Is my face in the right position? You look perfectly fine, Sister Jenny. Is my chin not being cut off? I'm just going to add you to the screen. Hello, Kaya. How are you? I see we've lost Sarah Jane. Can somebody get Sarah Jane back on? Your chin is not cut off. It's just the frame. Because your frame is limited, you will think and perceive that you are showing less of yourself, but you are perfectly fine for the production. Okay. All right. Can you hear me and see? Yes, I can. Fantastic. Everybody's looking beautiful. We will start at 2 o'clock. It's about 4 minutes to go. And I've got beautiful CVs. And what I'm going to ask everybody to do is, I like to do this. I like to always ask people, how do you prefer to be introduced? So when I ask you to come on board, over and above me saying how we have met and how we know you, the context of knowing you, part of what I will say to you, how would you like to be introduced? I have been using this for the last 4 months, and I think it's just a beautiful way of creating connection, not how you would like people to introduce you, but if you were doing your introduction of yourself, what is your story? Please can you just, Sister Jenny, to stop putting myself on. You could have told me this yesterday, though. Well, I'm saying that's how we're on the go. Sister Jenny, and for everybody in this production, can I please ask that we only have Levu taking us live. Sister Jenny, when you go live, when you put yourself on screen, my team, it just messes up with how the team have scheduled things. At present, because even though we are live, the audience doesn't get to hear what you're saying. But as soon as you go live or you put yourself on the screen, everybody gets to hear and see you. So I won't touch the add now. Please do not. Yes, please do not touch the add button. So if you've got any last minute touch-ups that you'd like to make, do so now. You've got like 2 minutes. Trust me, I'm the one who's been running around saying, oh, my hair is a mess. Well, I don't have much hair, so you can imagine, obviously. Always a bunch of nerves, but I'm sure we're going to have a fantastic session, and I'm definitely looking forward to this one. Great. Thanks very much. All right. I just want to confirm, so do I just need everything? Sorry, I have two voices coming through here, Sarah Jane. Sorry, so Sarah Jane. I just want to know if we need to go on mute on the big screen, on mute and off camera, or must I leave it on and you'll do whatever you need? Yeah, just leave it on and the team will do what they need to do. Okay. Yeah. If we do need to ask you to go on mute, the team will ask you to do so. But they'll send you a WhatsApp message. So just please note your WhatsApp message. Okay. Good luck, everyone. Fantastic. We're looking forward to this one. Okay.
Speaking your sound up as you're talking to them. But we tested it.
We were very close. The other time I asked the ladies to take it to like the corridor or something.
Oh, good. People are walking up and down.
I need to ask her to open the right. We've got a minute to go. Is everybody ready?
Can't take to the corridor. It's not long. It needs a plug point. Guys, at least until I figure out.
the third in the series of the Entrepreneur's Guide to the AFCFTA. In this session,
Manage this computer for me.
a broadcast channel, and a space or ecosystem for engagement. And the third reason why we exist is to ensure that we facilitate access to skills and capacity building through either scale-up programs, strategy coaching, and facilitation, as well as leadership development. Earlier this year, Womanomics Africa commissioned a platform to facilitate virtual connections for our ecosystem partners. For those of you who've made it to our campus and are joining us through our virtual Womanomics Africa virtual campus, welcome. We would like to take a few moments to help you navigate the campus, because whilst you've joined us on the broadcast facility, we'd like to open up your perspective on what else you can do here. If you look on the left-hand side of your screen, you will see a number And are joining us through our virtual Africa virtual campus. Well, this conversation and contextualizing a little bit more for us. Talking to the World Bank 2020 report, Women in Trade 2020 report, it says that and indicates that trade has the potential to what they say dramatically improve women's lives, expanding their role in the economy and decreasing inequality and expanding access to skills and education. This is both in the context of employees and in organizations that trade with women, as well as with those who are women traders themselves. The changing global economy offers new opportunities for women through modern services, the global value chains, for women to participate more integrated in these spaces. And the digital economy is finding ways in which we transcend some of those barriers, bypass them, and expand entrepreneurial reach. What Africa offers is a promising opportunity for both growth and development, and also significantly investment. Yes, investment. We hardly have this about how women
Maybe I don't have to put it on.
Ever sheds in Sutherland. For some reason, that's a tongue twister. And she's an IP practitioner. Welcome, Sarah Jane. I'm just going to be introducing everybody to the stage and then just framing how the discussion will flow. I have Kaya Tokoto, who is an entrepreneur and MD, founder, creator, innovator at Altex, and Altex Spark. And I think that she's an entrepreneur we've had great opportunity to work with, and she works in the space of technology and technology development. Last but not least, we have Miss Sister Jenny Gentile, and she is owner, founder, and also originator of Sister Jenny Gentile Touch. And she's basically in the manufacturing space, and she produces a cream which is world renowned, and she's here to tell us a bit about her story. Welcome, everybody. A short welcome before I redirect the program and share it with everybody. Hello, everybody.
Hi.
Hi, everyone.
Hi.
Hi.
Hello.
It's such a pleasure to be having you here. The flow of the conversation today, and those of you who are joining us on the platform and you're seeing your screens a little bit narrow, I'm going to ask you to just press the expand button so that you're expanding your screen and you have a beautiful full screen that's also reflecting all our speakers. So I'm going to stay on the line with Kaya at this moment. So this is how we're going to do it. We're going to tell the stories, and each entrepreneur, and Kaya is the entrepreneur, and Sister Jenny is an entrepreneur who will share with, and then we're going to have Sarah Jane joining us finally, and Sarah Jane will be telling us her story, or not really her story. She'll be reflecting on the journeys of the entrepreneurs. Kaya, I met you a few years ago. I think the first time I met you was at an alumni lunch. And I was intrigued by this young, fiery, independent tech innovator who seemed to be doing such amazing things. And a few years later, I picked up the phone and I called you when we were looking to develop the kind of platform we're currently using for this production. You have a story about intellectual property, your own personal journey. I'm going to ask you to start this conversation with an introduction of who you are and tell us your journey and why intellectual property is a conversation that has come to light for you as a significant area for business, and what your experience was, and some of the pitfalls. I'm going to leave this to you now. I'm going to take myself off the
clients weren't coming back. So in trying to figure out what the problem was, we found out that a lot of our clients were startups just like ourselves, were SMMEs, and they did not have money, and they quickly ran out of money. There was no money for marketing, and people would just rather go back to using the Gmails and Hotmails and whatever other generic emails were there outside. So we sat down and we really wanted to find a solution to what our problem, to the problems that was faced by our clients. So the one thing that we came up with, I don't know, I think most of you would remember, especially if you're in South Africa, there's a platform called Please Call Me. It's still there, I think, where people you could send a message free of charge, and you would just send a message to whatever number, and it comes with a short message saying, please call me. So after a while, you were able to customize that. Instead of your number, you could put your name, or people started becoming very, very creative around it. And they would try and, squeeze in as much as possible within that 10-digit space. So that is really what inspired us. My partner came up with me one day and he said, Kaya, if you look at it, at the end of the message, there was an ad, and usually it would be like an insurance ad. And we thought that, imagine if actually we could, those ads would actually pay for a call, because more often than not, the person sending a please call me is sending to another person, maybe a friend to a friend, or a boyfriend to a girlfriend. And the person receiving the please call me probably doesn't have airtime as well. So we were just thinking about that and playing around with the ideas and saying, you know what if that ad that's at the bottom could actually sponsor a call, and you're able to say, happy birthday, my darling, or please call me, or I'm outside, somebody's outside waiting under the window, or whatever it is. So that was the idea. We researched about it and we found out there was nothing on a commercial level, So we were based in the Eastern Cape at the time. I'm from the Eastern Cape. So we went to the Eastern Cape Development Corporation, did our presentation, we're very excited. And the response was, you guys are speaking a lot of big words, big English, but we don't quite understand what you want, but we'll support you nonetheless. So they got us a company to help us just contextualize what we wanted to do and just put it in nice format, and to be able to see and know what we were going to do. So long story short, we found that the idea was actually indeed patentable, for lack of a better word. You could protect it. There was nothing like it in the world. And so what we came up was a platform called Umoya, and the name that we were inspired by that name from air. So just air, and everybody called airtime. Airtime was Umoya as well. So this platform would allow people to be able to make calls free of charge across networks, and at any time there was no restrictions as to what hours you could call and whatnot. But obviously they're short calls, and everybody would ask. So every time they would ask us, what's the catch? So obviously the call is sponsored by an ad. So that's the ad that pays for the call. And we went on to get a patent for it and protect it. And we're thinking, this is our ticket. So excited, we're going to be rich. We were invited to Silicon Valley. Black Box had us there. We were presented, we won Silicon Valley Open Doors. We just really got a lot of attention from different people. And to a point where we were supposed to then start at an accelerator in Silicon Valley. And at the time, as we just signed from them, we received a call from a network in South Africa. So our technology did not require any of the networks. But the thing is, a lot of the networks, including the ones that invented the Please Call Me, they have a lot of people in their database. So our problem was we needed to go to market with a huge database. So if we, for example, we had an interest from Coca-Cola during the Rio Olympics. And at the time, after we'd done our proof of concept, within 2 weeks, we had over 600,000 calls made on the system and over 100,000 downloads of our platform. So, but Coca-Cola wanted millions, and we needed to then partner with somebody who already had a database of millions of people to be able to get then those partnerships going. So this one network called us, and it was truly, truly an exciting time for us. And then we had to say goodbye to Silicon Valley. We're like, no, you know what? We'll come back. We're going back home to Africa. We want to do this properly. And once we have this done, because it's a solution that could be replicated, I mean, to the rest of the third world, so to speak. So Africa, because connectivity and data is really expensive, or it truly was expensive at the time. And it's something that we were looking forward to, and we were so excited. And also it answered the question of, because every time we would present, the question would be, how far have you gone in your country? And we'd only gone as far as a proof of concept, you know, with 100,000 downloads. So it would have been really, really great, and sort of increased our case. And I mean, given weight to our case to have said that we've launched in our country, we're commercial right now. No longer able to continue with you because but we're no longer aligned, so to speak. And that was a huge blow for us. We're still a small company, and that left us, this was literally on the eve of the launch. All right. So this was at the eve of our launch. And at the time, we had already raked up, you know, a bill of over R1 million in terms of advertising, launch. Oh. Hi, ladies. I can hear Sister Jenny in the back. Yeah. All right. All right. Thank you. Okay, so to continue, so that was the first bummer in the works. Now our partner dropped us, and we had basically dropped everything to do that, and we really had no recourse. So following up with them, we found out, I mean, what can they do to help us? Because the way everything was arranged was that we would sign all the contracts with service providers and just invoice them. So when we followed up on that, the answer was, well, you guys, you know, go figure. You know, we have a legal budget of R1 billion, you know, so if you want to take us on, you're more than welcome. So that really just, those were major school lessons, so to speak, school fees, major growing pains. It's something that truly threw me personally into a cycle of depression. I wasn't sure what to do. But we tried to, you know, so in trying to remedy the situation, we got a call from another network within a few days. I was in the United States at the time actually of the launch, but my partners were down here in South Africa. So we had to rush and quickly go to Norway to meet up with their service provider, Ericsson, but they wanted us to launch in West Africa. So we sent everything with them. We sent, you know, our paperwork, our, you know, patent documents, everything for them to review, and they truly loved the idea. And they gave us 30 days to just regroup, select whether we wanted to launch in Ghana or Nigeria. And none of us had been to West Africa at the time. We did not understand how the market conditions were. They allowed us to choose a team, but I mean, at the back of being dropped by one network and still just reeling from that and trying to figure out how we're going to pay back the service providers and all the people that we disappointed, and everybody was really waiting for us to launch. It just was truly overwhelming. And this is when, I mean, I was younger then. I used to cry a lot. So I was overwhelmed, I was crying, and we sat down with my partners, and we decided to just decline the offer. We declined the offer because they couldn't give us more time anyway. We needed more time. We needed about 3 months to be able just to familiarize ourselves. But for some reason, the network wanted to go live in a month's time. So that was the second story. And then after that, things just, we started to relax. We relocated from Eastern Cape to Johannesburg, and we started moving on with our business. I mean, bills had to be paid, and we moved on. So a few months later, the following year, we got a call from a third network. So now this is how we found out. Well, they had found out that the other network that operates in West Africa had actually gone ahead and launched our idea without us, you know. And because of that, they then wanted to launch the idea in Southern Africa to be able to beat them. And we don't mind a little competition. We're like, okay, we're open to you guys. Come on, let's do this. We started conversations with them. And in trying to figure out, because I mean, they already had everything, we'd given them how our system works and everything, and trying to just understand what was happening, we then realized that our patent only covered certain regions and wasn't really covered, that was not really covering us for West Africa and whatnot. So there was nothing we could do in terms of pursuing that particular network on that. But we were having a new partner on the table and a conversation started with them. So this was interesting. We signed an initial contract with them, and then there was going to be a second contract which would allow us to now to go to all the other regions with them. And in one of the meetings that we had with the executives, a particular gentleman then asked me, he's looking us in the face and said, you guys look pretty young, good looking. We dress up really well for meetings. You know, it's just a thing that Sap and I do. So we were feeling pretty confident. We were all looking good. And they're like, the way, you know, and everybody had been giving us compliments that morning. So that's how it started. You know, you guys are looking very good. Whatnot. But would you consider a situation where we choose not to continue with you in other territories and rather go with a different partner? Because in doing our research, we then found out there was actually a company that was the service provider in the UK that had copied our technology. So they were thinking of that. And then he said that, but would we then be willing to sign something that says that if they don't go with us, we will not pursue or we will not sue that partner, their partner. And then I realized then that was the end of the meeting. I don't think this partnership is really going to be good or anything like that. I stood up, folded my notebook, and I walked away. And my partner followed, and then that was really just the end of the conversation when it comes to that. You know, everybody had egg on their faces. They tried to, you know, talk to us and be like, no, guys, it's not what we meant, but we're trying to figure out, you know, just in case, you know, corporate does not want to continue with a local supplier like you, if we could use our international supplier, what would that be? But also, I mean, that was also really a very, very painful lesson to learn, and then, you know, understanding, because from where we stand, from our understanding, when you register a patent, you have to say, you have to give everything, you know, and you have to, you know, just give how your system works, all the designs and everything in the different ways that it could be done. So there's also a risk in that. So if you have your IP and you want it protected, there's a risk, because it needs to be, you would need to spell out everything. And if you don't do that and you don't protect it and somebody still copies it, you'll still be at risk as well. So we just found ourselves in that situation. And of course, when you get responses like our legal budget is a billion rands. So if you want to fight us, you know, we're more than prepared. So yeah, that's the environment we found ourselves in when it comes to our journey with IP. Yeah. All right. Remember, you're on mute. I can't hear. Yeah.
Sorry about that.
Thank
I'm
you.
saying your story is, gosh, I can relate to so many elements of that journey where you are sitting back and saying, you're young, you want to make money, you've got these ideas. And we're sitting with a generation of young people who's hungry, who are coming up with these innovative solutions. We are on a continent that is so hungry for finding the new way to do things. And so it's exciting that you're taking that risk. You're being entrepreneurial. You know, you are not waiting for somebody to provide a solution. You're creating one where one doesn't exist. There's so many points in your discussion where, as I was saying, I was asking Sarah Jane, I'm like, do you want to wait till the end or you want to come in? And her text back to me was like, no, there's so many interesting issues that you are raising. And I'm going to ask them to cue in Sarah Jane onto the onto the screen, because I think that this is a conversation that I'm going to step back from, because I think there's so many legal aspects to this, Sarah Jane. I think that a lot of us call the likes of you when we are stuck. As an organization, we called Sarah Jane, I think it was last year. And until you are in the middle of it, until you understand that there are legal perspectives that come to play, you don't quite understand this environment. She's talking patents. And in my intro, I referred to patents and copyright. Maybe can you just reflect with us, what she's talking about, which realm of IP protection and world or universe that speaks to, and just maybe reflect on the journey that Kaya has walked, and share your insights from a legal perspective.
Sure. Thank you so much, Rema. Kaya, I wish that I had met you when you were all those years ago when you were so young. And just to introduce myself, we were going to do this at the end, but so I am in intellectual property. I am an intellectual property lawyer with Evershed Sutherland, and basically I live, breathe, and eat intellectual property. So Kaya, your story, it's unfortunately it's not isolated, and this is what we deal with every single day. I think the important issue in your story to understand is that you don't know what you don't know, especially when you're young, and you've got great ideas, and there are so many talented, creative people in this world, especially young people. And if I can give any advice, it is you need to get a lawyer. And I know people get very frightened when they hear the term lawyer because they just think they see dollar signs and they think lawyers are very expensive. But you absolutely, if you come up with an idea, the critical piece of advice that I can give anybody, whether you're going to file a patent for your technology or your invention, or whether you're coming up with a trademark for the brand of your company or what you want your company or your product to be called, is honestly not to disclose it to anybody as far as possible. If you need investment and you are still navigating the commercial field with your IP, it is really important to get some commercial agreements in place. Most importantly, a non-disclosure agreement. Of course, startups don't have a lot of money. And so whether you're going to enforce your rights or not, that's a whole different conversation, because it does cost money to enforce your rights. And protecting IP is it's not the magic solution to stopping all third parties. And you've described some really interesting aspects in your story. I was interested to know, you mentioned about a patent that you had obtained, and that you have to disclose, of course, you have to disclose what your invention and your technology is. So I'm sure most of the people on this call are aware that Coca-Cola have never, ever patented their recipe. For that very reason, is that sometimes it is not in your interest to get a patent. If your invention or technology or your recipe is so cutting edge and secret, and you wanted to keep it secret, it may not be a good idea to patent it. But this is the kind of advice that you need to get from a lawyer, because a lawyer will help you to construct your commercial agreements right up front before you engage with third parties. I find especially women are so trusting, and we excited about this invention or new ideas or this new business that we want to take to the market, and we want to take it all around the world. But if you don't know how to protect yourself and your IP, then you're going to run into troubles just like your story says. So thank you for sharing that, because it is a really interesting story, and there are so many IP issues. So I don't want to confuse the listeners, and I'll get onto my presentation a bit later. But would you have any questions for me, Kaya?
Yes, Sarah Jane. I mean, the first one you actually mentioned NDAs, and this is one thing we find. I mean, we had our own NDA drawn up, so we had. I'm trying to figure out now this organization. I just forgot the name. They innovate. Okay, I remember them. But anyway, we were assisted now in drawing up, just basic contracts and things like that. And every time we spoke with these networks, they refused to sign our NDA. So that is always the answer. No, we do not sign external NDAs. However, if you don't trust us, don't come to the table, don't take the meeting. Or they would rather than give us theirs and we have to sign that. So every time, we just felt so bullied, or you feel that, we're so hungry for opportunities, and we really truly want exposure. We want to go to market, and that is the biggest thing. I mean, it just basically, the minute you mention NDA, it's very shocking.
Yeah, unfortunately, sometimes you're negotiating leverage with bigger companies and organizations, and as you say, they have got an unlimited budget to fight you, or to, if you take them on, to defend it. So that is a really difficult aspect in entrepreneurship, is especially when you engage with big corporates. Your leverage is so little compared to theirs. And it's interesting that you did do all of that, but of course, if you wanted to take it further, you would have had to spend more money in trying to find them. And it's such a wrong attitude, actually, to say, well, if you want to take us on, take us on. We do a lot of litigation in my practice, and where people are enforcing their IP and defending enforcement at the same time. So it does sound like you did things the right way.
We tried.
Yeah. Just one other issue that is important. When you come up with an idea, or it's a business idea, or a product, or a design, or an invention, our recommendation is always that you test it and launch it in your own market before you take it to other markets, because you can protect it in your own market, and it's quite a good test case to get a measure of reputation, goodwill, credibility. It really does help your leverage when you start taking your IP offshore and you start engaging in foreign commercial transactions. Rahima, did you want to come in?
No, I'm listening to this and I'm like, I'm that person who can have this conversation for the whole day, because the gems that are dropping, and I know that you will be sharing a specific, legal outlook on generically, not specifically to topics, but already, I mean, there's like 3 key gems out of this discussion, Kaya. And it's always like too late, right? We do the right things as entrepreneurs. We are told this is the way to go. Sarah Jane, you have floored me when you are saying sometimes it's not worth patenting your IP, because as women entrepreneurs, we are often lambasted for not doing the whole route of going and protecting. We're having lots of conversations says patented, protected. One is the cost factor in going that route, and when when there's a perspective out there that says, actually, if you really need to keep it tight and close to home, perhaps that's not the route, because what you're effectively doing is sharing with the public that information. And I think that kind of throws us, right?
Yeah.
And then the second one that you've raised for me is this whole notion of, and I think Kaya raised this, is saying that, you're putting in work like your NDA. So we've been told as entrepreneurs that make people sign a non-disclosure agreement. And just this whole notion of what is the real leverage power of that non-disclosure agreement, first of all, in enforcing it, and second of all, in actually getting people to agree with it. And how does that lock out the doors? I mean, I'm now sitting back and writing notes for your session when we're doing the Q&A with you. And I think the third piece of advice that comes out of Kaya's experience, and Kaya, big ups, and thank you so much for the vulnerability of sharing that. And you are very young. I know this for a fact, that you're very young, but to have been able to take a business, and I wrote here, from Eastern Cape to the world. I think that's exactly it. We talk AFCFTA as if, we are opening brand new doors, but young African entrepreneurs are going global. They are engaging with the world. And this whole notion of launch it in your own markets, I mean, that for me is a big reflection as we're seeing that the world is getting smaller. Global markets or global operators are coming into our space. And so do we stay here and try and grow here where it's such a limited space? or do we open up and try and go into those other spaces, but we then suffer from the kind of protection? I think the bigger conversation around the AFCTA is what is the protection potentially going forward for Africans within the African free trade area. And I know that that's a discussion they're bringing on much later, but to be able to say, if there are global protection laws, what are the local protection laws that we can be protected by? And I know we've got that within South Africa, but what is the Africa context? Because really, looking at a 55 million or 58 million population versus a 1.2 million, it's a no-brainer. We want to go out. But to bear that in mind of saying, well, if you're going out, think of these three things. So Sarah Jane and Kaya, thank you so much for bringing that discussion up and for giving us that lens. And I think I'm a firm believer in story, in the power of story. And I'd like to add Sister Jenny to the chat as I bid farewell to Sarah Jane and Kaya. For the moment, we will have a Q&A right at the end, which allows us to evidence or bring forward a few more of the conversations. And so I'm going to introduce Sister Jenny at this point in time. Sister Jenny is a co-founder. She's not a co-founder. She's an owner, an entrepreneur, and basically the work that she's works in is in the medical field. She's created a cream that a lot of people who've had the opportunity to use swear by it in terms of its healing capabilities, particularly in burns and in injuries that have been experienced by people. But Sister Jenny's got a unique story to tell of being that South African entrepreneur who has ventured to the world, and the world has not responded kindly in terms of respecting her intellectual property. Sister Jenny, welcome to the session. If you'd like to introduce yourself and tell everybody about your story and journey with managing, protecting, and sharing your intellectual knowledge and property.
Hi, everybody. Can you see me?
Yes, we can. We can see you clearly. Thank you.
As you know, I'm Sister Jane. I'm the inventor of natural healing creams. I'm a professional nurse. And I'm also an entrepreneur. And I specialize in therapeutic reflexology. And I've got a story to share with you. It's a very passionate story of 29 years. So I don't know why I can't see myself on the screen, but I'm going to tell you my story. Can you see me? Okay. I'm just checking that my screen is sharing. Just hold on. Okay, so here goes. So I've always been very, very passionate about healing since I was a very young child. And that's why I became a professional nurse. And in the hospital for 18 years. And after working in the hospital, I noticed, while I was still working in the hospital, there were so many people who had these cracks in their feet, diabetics, and they ended up having leg amputations. So in 1992, I started working on a range of creams, and I left the hospital and decided to create a solution for diabetes.
We seem to have lost Sister Jenny for a while there, so I'm going to move up on the program whilst we get her back. Sarah Jane, I know that the context is really about getting else to identify with somebody who we know has walked the journey, or ourselves in that journey. And that is the purpose of us sharing individual real life stories on this platform. In the absence of that, what we'd also like to lend to the table is that masterclass component from a legal practitioner to give us the ins and outs of intellectual property law considerations and just the framing of it. Why is it important to us? You've already heard one story, and I think from that you're sitting back and thinking, gosh, I'm going to make a lot of money as an IP lawyer because lots of people need more protection and a lot more knowledge, and we know this. We know personally that we've had to engage your services, even as Womanomics Africa, as we've navigated this field of having ideas, but also understanding not just how we trade with these ideas, but whether or not we should be pursuing certain protection, whether we should, litigate, or whether we need to step back, or whether we need to be more aware and more conscious of where we are funding the protection of our assets. And I think you've got some information to share with us that we'd love for you to spend this time now with the audience, giving them a sense of, guys, here are the ins and outs. Here's your masterclass on IP law and protection, which you would typically pay thousands of rands for. I can attest to that.
I'm sure. Okay, no, thank you, Rahima. It's very interesting when you're speaking to entrepreneurs and startups. A lot of people don't understand that ideas are not protectable. So if you come up with this amazing idea in your head and you talk to somebody about it, it's very dangerous to do that because there is actually no protection in ideas. So whilst the definition of intellectual property is creations of the mind and your human ingenuity, you need to reduce those ideas to writing or some form of expression. And so that is the first piece of advice. And for everyone that's on the call, I have prepared some really, I think, user-friendly, easy slides for everyone to have a look. I mean, IP terminology can be very confusing for a lot of people, but I've tried to dumb it down so people can understand the concepts of IP and what you need to think about when you come up with these new ideas and what you do with them. So I think a lot of you have heard about, and I use the example of the dinner with Somizi. There was a lot of publicity around that. And I did speak on 702 about it because that is a classic idea of, or a classic scenario rather, of somebody who had an idea about a concept and spoke about it, but didn't really execute it, didn't do anything about it, didn't put it into a business plan, didn't engage in an agreement. So there was nothing tangible about that idea, and somebody else took that idea. And of course, there's no protection in an idea. So when you come up with something that you think that you want to make money with and you want to take into the market and that you think is different from other people's goods and services, it's important to either get a trademark for what you're going to call it. This, of course, is another interesting area in IP, is that there are many different categories of intellectual property, and people, startups especially, get confused about what their IP actually is. So is it a trademark? What do you call your product? What do you call your service offering? That's a trademark. Is it a patent? And Kaya was talking about a patent for their particular platform and technology that they were talking about. Is it copyright? And copyright is all pervasive. It exists in many scenarios for your brand name, for your brand device, for your books, for your business plans, your presentations. Copyright, unlike any of the other categories of IP, doesn't have to be registered. And it's a very strong form of IP. But there are also, of course, domain names. There's your intellectual know-how when you work in a business and you run your business in a certain way. Over time, that becomes very valuable intellectual property, and you can't register it because, of course, it's your way of doing business, and the public have come to associate you with that kind of way of doing business. So that's a form of intellectual property called know-how. And then just the commercial considerations around IP. So once you've got your head around what kind of product you want to start putting into the market or your service offering, once you've got an idea about that and you understand what kind of IP you want to protect around it, it's really important not to forget the commercial side. And the commercial side is, unfortunately, the paperwork. And nobody wants to do paperwork, especially when you've got this great idea. You just want to get going and you want to talk to as many people as possible. And it's important to have commercial agreements in place, really, even if they are just 2 pages, where your idea or your product or your design is documented, and you make sure that the other person involved that you're contracting with, you must make sure that they understand that it is yours and not theirs. Of course, if they copy you or they steal your idea, you do have to spend money to enforce your rights. But that's a whole nother conversation, and I'm sure Rehema can also talk to that. That's how I got to meet these lovely ladies. But there are people out there who will want to leverage off your hard work and your creativity. So it's important to try and have all bases covered. Just going back, and something I thought about when Kaya was talking, and I forgot actually at the time Rehema was talking to me, but where I said sometimes it's not a good idea to disclose an invention, especially if your invention is cutting edge and you want to keep it secret. The counter to that is that if you are engaging with multinationals or big corporates, you may need investment to get your business off the ground. And I think Kaya's story is quite relevant, because when you're a startup, you don't have a lot of money behind you. And people that you engage with will say, well, we want to invest in you, but in order to invest in you, we need to know that your intellectual property is protected. So in that scenario, your hands are quite tied, because your investor will want to see that you've got a protectable patent, or you've got a trademark, or you've registered in different countries, perhaps, if you want to take your idea offshore. And in that scenario, they will insist on a patent. But then, of course, you are tied up with investment. So they've got skin in the game, and there's no reason for them then to try and pull the rug under you, because they've invested money in your operation. So in that scenario, you wouldn't really have the luxury to decide whether you need a patent or not. But again, very important, when it comes to patents, you are not allowed to disclose to anybody until you've protected, because that will destroy the novelty of what you're trying to protect. Unlike trademarks, you can talk about your trademarks and then protect them. That's fine. But patents are very different from that. And in the presentation that I've prepared for you, and that I don't want to speak to it, because I like this conversation, and I think it's very relevant to have conversations about IP, because it's a subject many people don't understand. But in the slides, I've set out the different forms of intellectual property, and I've also given some indication of how you protect cross-border. And of course, I'm using only our African continent, because there is such trade gateways between all the different territories. And there are different ways of protecting, for example, your trademarks. I assist many people all around the world protecting all forms of intellectual property and enforcing rights in intellectual property. So it's very possible. And South African entrepreneurs need to understand that it is very possible to take your business around the world and offshore, but get your house in order first in your own country. See how your market reacts to your product or your service offering or your invention, and start here before you take it offshore, because there's money involved and there are many considerations involved in engaging with people who are not our culture, who don't understand the way we do business in this country. Rahima, I don't know if you've got any questions at this point for me, because I could babble on for all the session, if you like.
Well, I think I've got a couple of questions for you, and I think that the first one is, you talk about your first line of defense, right? As an entrepreneur, so and I think that that's important as an entrepreneur as we're walking this journey. I think for me, part of the question that I have is, if you are going to be talking about stuff, because the entrepreneur's journey is often coupled with a journey of funders, and it's coupled with a journey of not just sharing the final product, but the development phase, because you do need to a certain level co-create. Now, my question, I guess, is twofold, right? If you're asking people if we're starting off with the NDA, it doesn't mean anything, really. Who does the NDA mean something to? And how enforceable is an NDA? How do you use it as an instrument practically, other than saying in principle, I've got this document? What is it? What's the word?
So it is, an NDA is, you hope that the effect is a deterrent, and you are putting your rights in a document to say, you are not allowed to disclose my invention, or no, let's not talk about invention here, because that's patents, and that's a really different area, and I'm very happy to spend some time on that, because it is quite important. Let's say you come up with a business idea and you engage with a potential investor because you have no money, and you need a co-creator or you need a co-investor to get your idea off the ground, and you enter into an NDA. And really what that NDA is documenting, it's putting an expression to your idea, and it is telling the person who you are engaging with that it is mine, not yours. And of course, with all things legal, if you want to protect your rights and enforce your rights to that NDA, you then, of course, have to spend money, because a letter of demand in most instances won't do the trick. Of course, you've got to start any kind of action with a letter of demand, and many people are, let's say, upstanding enough to comply with your demands, and they realize that they've entered into an NDA with you, for example, and it is yours and not theirs. But some people just ignore that. And then you actually have to enforce your rights in a court if they ignore that and you've suffered a lot of damage. So everything is a case-by-case assessment, of course. But it is worth it, Rahima. And we assist clients on a daily basis who, like Kaya, I think she did it the right way. She seems to have had advice, and she did get into some agreements. But you won't believe how many people don't do that. And then they approach us when their product or their name or their design is being copied or stolen. And there are enforcement mechanisms around that scenario. So whatever paper trail people can keep, emails, NDAs, and keep your evidence of when you've started up from as far back as possible. It all helps to prove your rights against a third party rogue, let's call them.
I mean, that's fascinating. I mean, I always look at business and we always assume that business is formulaic, right? And process driven. That we are always told that if we follow a particular formula, that's a formula for business success, right? You start off with an idea, then you have a business plan, then you go for funding and you operate, and it's hunky-dory. And there's so many things in between that we know just make that a redundant kind of statement, that it's great to have these things on paper because they kind of channel your way of thinking. But if you were to give an entrepreneur's dummy guide to IP protection, what would that look like? And I'm saying it in the context of, from the moment that you have this thought and idea, and typically ideas are great ideas are not not defined by one person. That point where you have engagement with other people, where that idea is then developed into something else, and then you create a product, a service, or an offering that's got a tangible interface point. And at that point where you are then transacting with people, what's the IP journey? What is IP along that, and what's the IP journey? And I mean, we'll answer this, and I know that Sister Jenny is going to be queued in, so we will be bringing her in just to let her know that not losing out on the discussion. But perhaps, you know, as we conclude this particular session here, is just to say, what is an IP? What's a typical IP journey, and what are the considerations along that journey in terms of the nature of protection when that comes up? But also give us an indication of cost, because this is not cheap.
No, it isn't. And so I'll start right there, because it talks to your answer. I mean, your question. And so when you start your IP journey, you don't know, when you're starting a business, you don't know how successful let's talk about a product. You come up with this amazing vacuum cleaner, and you want to call it a particular name, and that name is what I would recommend that you protect. Because and the advice is, by the way, try to stay away from descriptive, generically used terms, because it is very difficult to enforce your rights. You need to distinguish yourself against other people selling vacuum cleaners in the marketplace. So you come up with this great vacuum cleaner, and you want to call your business Psychedelic.
Miraculous
Psychedelic for vacuum cleaners is not generic. And yeah, you want to call your business Psychedelic Vacuum Cleaners. Say.
Right.
Now that name is very distinctive for vacuum cleaners, because it's not common, it's not descriptive, and you've got your descriptive name called vacuum cleaners, but Psychedelic is your brand. And you don't know if this is going to take off in the market or not. But if you're going to invest in that business offering, and you want to make a go of selling vacuum cleaners, and you think there's a market for it, you would have done your market research before, I'm assuming. The first thing you do is you protect Psychedelic as a trademark, because then other vacuum cleaner sellers or distributors or manufacturers cannot use that name or a similar name, a confusingly similar name, to leverage off the success of your business. Say now your vacuum cleaner business takes off. You've got your trademark in place, and other people then cannot try and leverage off your name. And even if they use something like, let's see what's confusingly similar to Psychedelic, let's say Hyperdelic.
Yeah.
And I'm using very fanciful words, but I'm trying to illustrate that it's confusingly similar, because people are in a rush in their day-to-day lives, and they will then not pick up the slight difference in that name. You can stop somebody using that confusingly similar name, because they're trying to hold out to the public that they are you. So that's the first thing, is decide on a name for your product. And if it's a name that you are very invested in emotionally and financially, then you should protect it. And I'll give you a high level. There are very wide-ranging costs for IP, because it really depends on what you are protecting. And patents and trademarks are very different on cost, as I'm sure Kaya will tell you. So a trademark from start to finish to registration is probably going to cost you about 10,000 Rand. And that's assuming nobody objects to it or opposes it. It's a straightforward process. And you don't have to pay that all up front. You pay in stages, because in South Africa, for example, a trademark registration process has a life cycle of approximately 2 years. So as soon as you make an application for a trademark at the registry, you have got rights. Even though your trademark isn't registered on that day, you've still got enforceable and protectable rights. And then your trademark lies for a period of time, so it's about 8 to 10 months at the moment. The registrar examines it for registration, and he either accepts it outright, or he says, you need to do X, Y, and Z with it, and then I'll let it go through to registration, and then he accepts it and it goes through to registration. That's a very simplified, high-level process of trademarks. But as soon as you get onto the register, sorry.
So you have an idea and you put aside 10,000 rands, guys.
Well, yes. I mean, it's, and you know, that's the whole process. So that 10,000 is payable over about 2 years.
Okay.
But upfront, you're looking at about 3-5 to get yourself onto the register. And then once you're on the register, you can use that little TM symbol that you see all around you on billboards and advertising. You'll see a little TM, and that symbol indicates to the public that you have applied for a trademark. You've got a pending trademark on the register.
Right.
When it proceeds to registration, you're allowed to use the little R symbol next to your trademark.
Okay.
And I'm seeing a lot of questions. I just want to let everyone know I'm seeing a lot of questions on the side, and I will get to that when I'm not speaking. So I'll answer you on those. But thank you. I like questions.
Yeah.
So anyway, yeah. So that's really speaking about a trademark.
Okay, great. So what I'm hearing so far is you've got a great idea, and you know you're going to want to trade on it commercially. Start off by protecting or giving the idea an identity, and that identity is accept. You know what people interact with in terms of the identity is the name, which you can protect by trademark, and obviously by registering that trademark, you're also registering what it's going to be used for. So an association between
Correct.
and the final product that you will be trading on, right? So
Yeah.
you do that, you've got your trademark, right? And then I guess this is where you then go into the realms of once you're registering that trademark and you're going on to create products, this is where you're making the choices around whether you're going to patent what you're creating, your creations.
Yeah, that's slightly different. And one thing I didn't mention, and it's part of the 10,000, by the way, is
10,000 is great now, but wait.
you're getting a lot of bang for your buck. I just wanted to tell you, I mean, really, you come to me with an idea and you say, I want to call my vacuum cleaners psychedelic vacuum cleaners.
Yeah.
We don't immediately just put it on the register. We have to do an availability and a registrability search. And that simply means availability search. Is there anybody else who is on the trademark register already with the same or a confusingly similar trademark? Because we would never advise you to protect psychedelic if you were going to infringe another person's rights. So that's why the first part of that process is you need to do a search to make sure that your trademark is free to use and register.
So if you've got disputes there, it's because that part hasn't been done, basically.
Correct. And is that not how we have met?
Oh,
That is
I
how
wasn't
we
going to
met.
say that part, but I'm just saying that.
But it's very important.
But this is where entrepreneurs are putting a lot of trust in the legal fraternity, because this is a field that it's not an entrepreneur, although I'm understanding entrepreneur could go into this process. Typically, we're getting and engaging legal practitioners to come into the space. So it's almost like, you know, the reason why we go to school is because the teachers know more than us and we're learning from them. The reason why we go to legal practitioners is that this protection journey has got stipulated points and checks. But as an entrepreneur, I think these are the questions you should be asking is that where am I in this journey? What is happening? What is the process that I can anticipate so that if there are any challenges along the way, you are better informed? What is the role of the company's intellectual properties corporation? Because I think that's another, in the South African context particularly, that's a point of interaction that entrepreneurs have in terms of protecting, right? My understanding is that the legal registration of your company also forms part of the legal name and identity. What is the connection between that?
So that is a very interesting point as well, is that the companies register, even though they sit at the same commission in the same building, the companies register and the trademarks register don't talk to each other. And it is problematic. It's problematic for legal practitioners, and it's problematic for entrepreneurs, people in the public, because many people traffic under the misinformed guidance that if they have registered a company name, they are sufficiently protected from a trademark perspective, and they are not. So if you think that you have registered Psychedelic Vacuum Cleaners Pty Limited and you are fine for the rest of time, actually it gives you some leverage because you've got a name registered somewhere. But in terms of your trademark rights, you are very exposed. And that's why when we do an availability and a registrability search, we search both registers because we want to see, is there anybody else in the marketplace using the trademark that you want? That is a very important step in the process. And of course, we can't guarantee our results of our searches because we don't know how many people are in the market who might be using something similar, because that would just go beyond the searches. But we try and do as much as possible in a search. We check domain names, we check the company's names registers, we do internet searches, we do trade site searches to try as far as possible to guarantee that a trademark is available. So that is a really important conversation that you've raised. But the public engaging, because many people think, well, why should I use a lawyer? A lawyer is a lot of money. Why don't I just go to the CIPC on my own and do the process? And you can. Any member of the public can go to the CIPC, and they are very friendly and they are very user friendly, and they will assist you. However, they do very basic searches, so they will only search the trademark register and tell you, yes, you can trademark your name. Of course, they don't then do the counter search of the company's register. And then once your trademark is filed, it doesn't just lie there and get registered. You actually have to do things to get your trademark to registration. And in trademark speak, we call it prosecution. You have to prosecute your application. So remember I said it lies for a period of 8 to 10 months. The registrar examines it. So if me, Joe Public, I've gone to the CIPC on my own and I filed a trademark, the registrar is not going to send me, well, he might send me a notice and say, you need to do X, Y, and Z to get your trademark registered. But in the meantime, I've moved addresses. So I will never get that notification. And then my trademark will never go through to registration because I won't be doing anything with it to get it through to registration. And that's one of the reasons, Rahima, that we do encourage the public to use attorneys, because attorneys have usually got fixed addresses, or there's, if, you know, God forbid, if your attorney dies, there are other attorneys in the firm who can continue that process for you. So you will always be aware of deadlines and actions that need to be taken to keep your trademarks valid.
Yep. And an invoice with every notification of a change in process.
Some attorneys, not all. But it is, but here on the cost side, and I see that there is a question, what are the cost considerations? Going to psychedelic, the example of the psychedelic vacuum cleaners, you don't know how successful your business is going to be. Of course, anybody starts out really wanting it to be a successful business and investing time, energy, and money. And to protect your IP is actually an insignificant cost in the overall scheme of how you want your business to look and to compete with other parties. So if you want to make money off your IP and you're serious about investing in it, really the cost of protection in the greater scheme of your business is minimal. And that's why it's so advisable. Look, patents are different. You can pay anything between 20 to 35,000 to get a final patent. It depends on the technology you're trying to protect. It depends on the invention you're trying to protect. And in that, there's also searches, because unlike trademarks are country specific, which is also important to bear in mind. is that even though we are on the border of Botswana, say, my trademark in South Africa is not valid in Botswana because I haven't protected it there. And so trademarks are very important wherever you are going to distribute your product, sell your product, trade with your product, and your product is doing well, and you've registered in South Africa, remember that you need to also protect it in those territories. And it can be a very costly exercise. So you have to be, sure of your core markets. And that you will only get to realize over time as your business starts to expand and you see where you want to expand to.
I mean, that's a great point to stop, right? Because I think the next speaker that we have, thank you so much, Sarah Jane. Stay on the line. I've got lots more questions for you.
Yes,
this is like free advice now, right? There's no invoice at the end of this one. So
you must remind your delegates that they don't need to pay for the presentation. That is very valuable. Pay for the presentation.
I have to just reiterate that IP lawyers' fees, guys, are not cheap. So I hope you really optimize on the information and content that we're getting here.
Yeah.
Thank you, Sarah Jane. I think we'll get you back on after I think the story that's going to be shared by Sister Jenny, and I'm just going to cue her in, Sister Jenny. Is precisely one that speaks of doing business across borders and what can go wrong when you're not protected in different global markets. So glad to be inviting you to the platform again, Sister Jenny. I think it's been a long time coming. If you do have issues with your camera, please just switch off the camera. We'll be able to see your content because that's great. And I know you're looking absolutely beautiful. You look stunning, looking beautiful as always. But if it does help us for us not to have your video on, I'm going to ask for you to have it off. I see she's gone offline again. I think this is a reality that we are having of the times that we're living in. We just did an initiative. And one of the things about intra-Africa trade and using technology as a lever is the reality that technology has got its challenges in that women's access typically to data, to infrastructure, and to networks makes it difficult for some to engage, which is why we're using a platform which allows us to stream to multiple environments, but importantly, to be able to share the information so you can have access later. We will have access to Sarah Jane's content later on. There's a YouTube link as well, so you'll be able to direct people to the YouTube version of this conversation. But also where we've got content that's been shared by the speakers, we will be able to share that with you at a later stage. Sister Jenny, can I just hear whether or not you've been able to connect with us? I'm just going to ask the tech team to just do a check with Sister Jenny. We see challenges with Sister Jenny. She's on and off and on and off. So I'm going to ask Kaya and Sarah Jane to come on because there was a question that was asked by Kaya. And I think it's a pertinent question that was asked, that given the complexity of her journey of also, and you've said that you kind of have done all the right things in this journey. If she could do one thing differently that could have helped her on this journey, what would that be? Am I taking the words out of your mouth, Kaya? Because you're like, I want to know if I'm to walk this journey again, what can I do differently? I mean, it was a bit of a complex journey. So perhaps maybe isolating one area where if Kaya did something slightly different, it could have changed the outcome. Or if you need clarity to answer that, please.
Okay, so Kaya, is that your question on the right? That's Sarah Jane. My question for you is, if we had an opportunity for a redo, what would be the best course of action? That's your question? Okay, so, all right. So interestingly, I don't know your whole journey. I just, from what you've said, what a lot of people do, or what we are seeing more and more of, because people have been burnt the way you have been burnt. If you have a great idea or a invention and you want to take it offshore, we are advising our clients to enter into non-disclosure agreements and to enter into escrow agreements. And it's quite a novel way, because you get the person that you are engaging with, whether it's an investor, somebody who's really interested to use your business and get you off the ground, we say, all right, sign the NDA. We're not disclosing any of our intellectual property at the moment. We've given you an idea on a business proposal. And on your business proposal, by the way, you would have had your copyright strapline. For example, Kaya, copyright 2021. You must put your copyright straplines on every single page that you have put together with information from your business. So that's your first thing. Then you sign an NDA and you say, this is the general idea of my offering, but I'm not going to disclose the details to you yet because I want you to put a certain amount of money into escrow that will protect our negotiations. And so that, and then you do an escrow agreement that says, if that person steals your idea or does not follow through with what they've said they're going to follow through with, or put in the money for investment, etc., you have got an amount of security, financial security, that is sitting in escrow. So we are finding that is quite a unique way of engaging at the moment. Some organizations are just not responsive to that at all. But we are trying to get as much as we can for our clients, as much security as we can. So once you've got your trademarks in place, your patent registered, if you're going to register your patent, then we say, right, if you want to talk to us, if you want to work with us, if you want to co-create with us, put an amount of money into escrow that secures our relationship. So that, just from what you were telling me, might have been a solution, because it seems you got all your agreements in place and everyone loved your idea, right? And that's why they stole it. And that, unfortunately, is the way of the world, and it's very sad that we have become like that. But that is what happens. So now, if you want to talk to me, so if you and your partner come up with another fabulous idea,
Which we have.
okay, good. Come and see me. Come and
Commission!
But so when you come up, don't disclose everything up front. Just give high level information so that they can't access actually what your technology is, or what your business method is, or what your operation idea is. Give high level information. So be as secretive as possible, and then get agreements in place, signed, and try and facilitate an escrow so that there's some proper engagement and skin in the interaction.
Sarah Jane, just one question with that. If there's no patent in place, because I'm really wanting to explore that, because we really have not really, we haven't really felt the benefit of having a patent, then can the escrow agreement still be in effect?
Absolutely. So let's talk about this, the delicacy of patents at the moment, because I think it's important for the audience. So if you come up with this idea and you haven't protected it, you can't protect it after the fact of disclosure. And that's why if you're talking about an invention, because it destroys novelty. So one of the requirements, and you'll see it in my slides, one of the requirements for a patent is that it has to be new and inventive. And in legal speak, we call it novelty. If you talk about your invention to a third party, or you put it down in paper in an agreement that you're engaging with a third party on, and it's outside of confidentiality and non-disclosure, it destroys that novelty requirement. And then it is in the public domain. So many people think that they can talk about their invention, raise money for their invention, get investors, and then protect. You can't do that with a patent. You can't do that with a patent. So patents are, the key word here is secret. You mustn't talk about this, to your invention, to anybody. Only in your bubble of your business partners. If you're going to be talking to investors, you do non-disclosures with high-level ideas, but you don't disclose the technology, you don't disclose the operating system, you don't disclose the recipe that you're trying to protect, etc. So you can engage, but you don't disclose what you are wanting to protect. Once you've got the investment, then you can protect, because they don't know what the technology is, they don't know what the recipe is, they don't know what the invention is. So you've not disclosed anything. You've just given them a very high level idea of what it will achieve, for example.
Yes.
So you give them an idea of what it will achieve, and you get them interested, and they say, no, we really like that idea. And you say, right, well, before I patent it, you need to, what are you wanting from me? What are you wanting to engage with me about? Because I'm not prepared to protect my technology, invention, recipe, operation until such time as you've put money in the game. When you've done that, we will protect the patent. And you can then decide whether you want to keep the patent or whether it's going to be a co-owned patent. Usually when there's investors involved, they will insist that they co-own, because then you both own the patent. Of course, it's a whole nother conversation, and you've got to decide if it's the right thing at the time for your business, your partners, etc. But that would be a way of doing it.
Oh, wow. Thank you so much. I mean, so many mistakes. I'm just thinking now already of the conversations we've had just within our circles, testing the ideas, within our networks to find out, will it take off and everything. And now I'm just thinking, okay, we need to just bring that back in.
Yes, dumb it down. There's no problem in giving a general high-level explanation of the idea, but be careful that they don't have enough information to steal it out from under you, because it's a double-edged sword. It's a double-edged sword.
Because the heart of creativity presumes collaboration and engagement, right?
Absolutely.
For the very reason, particularly, I know the questions that we've had over the last 10 years just to try and create a technology that can do this kind of thing, that obviously it's accelerated over the last few years. And if one was not having those conversations, we wouldn't be where we are. So one is wondering, if you're saying don't have, this is the fine line, I guess, around how you're protecting along the life cycle, when to protect, what to protect. So I love the journey that you're mapping out, saying, trademark it so that, you've already put a name and identity towards this thing. But this whole, I think for me, the blurry area is that creation place, that innovation space. What you are starting out with is not what you're going to end up with. And if that is the case, who has got ultimate rights to the final product, given that it goes through a number of iterations? So a couple of questions are coming in for me. One is that who's got the ultimate right? But importantly, what is the life cycle of ownership of trademarks, of patents, of copyright? What's the lifespan of that, and are they really exclusionary, or is it just that it incurs litigation should you go against? Does it really prevent people from doing stuff?
Well, it does in a lot of situations. It really does, because the minute I buy some soap, and if I'm also a soap manufacturer and I pick up a bar of soap and I see that there is a TM next to the name of the soap, I'm automatically alerted to the fact that somebody has got protectable intellectual property rights, and that I should stay clear of using that name or a similar, confusingly similar name. So immediately it puts me on guard, and I think, sure, my soap must be very different before I take this into the market. So you are on high alert immediately. And just to answer your question about how long IP lasts for, it's different for the different categories of IP. And I have set it out in the slides. So a trademark it's valid for 10 years, then you have to renew it for another 10 years. So trademarks are valid for as long as you renew them. Patents are slightly different. They are 20 years. Copyright is different, and it is in the slides. But it puts people on high alert that you have got protectable interests.
Okay. Well, we can hear you coming through.
Can I just answer this other question, Rahima, so that I don't forget?
I'm letting Sister Jenny know that we can hear you, Sister Jenny. Please be on standby. So you're on stage because we're looking for you to join the conversation. We are missing you on this conversation, so we will be able to hear you shortly. Yes, Sarah Jane, if you may, please.
Okay, I think the second question has been answered. What are the cost considerations for entrepreneurs to initially protecting and then possibly defending? Look, I'm not even going to get into the cost of defending because it really depends on what you're trying to defend. And it depends how big the claim is, etc. But litigation is very costly. Yeah. And I try at all accounts to resolve matters before it gets to litigation. It is not in anybody's interest except the lawyers. But it is a lot of time, energy, money, effort, and it diverts you from your own business. Yeah. So as far as possible, do things the right way so that we don't have to fight for you.
Yeah, very, very wise words.
Yeah. Good. Okay, I'll leave the floor to Sister Jenny now.
Okay, great, Sister Jen. Thank you so much. And I think we'll be bringing you up on board just to close up the conversation once we're done. Sister Jenny is not having a great technology day. So every time we say, let's bring her back on board, and then she does end up disappearing from us. So I do have another question for you, Sarah Jane. And this is really from a perspective of industries. Are there any industries where IP rights are perhaps more difficult to protect? And are there any others where, for instance, IP protection is null and void? I mean, this is an interesting one for me, right? And I think this is also considering COVID, the whole, I think for me, it's a moral question around IP protection and vaccinations in what has been deemed humanitarian crisis, which typically has the law thrown out the table, but here the laws come in full protection of big pharma, as an example. But are there other spaces where it's protected? Because I mean, there are certain spaces where we think that the law is meant to protect the greater good, but it seems like the law is out to protect the greater profit. So the question, what does this look like? I mean, what is context? Are there places where IP should not be allowed? And because I think COVID is a perfect example. There's a humanitarian crisis, typically, which means that everybody takes away from charging and making a profit out of something. But here we've got a unique situation where profitability is at the heart of the protection of IP. Talk to me as a layperson to make me understand.
Yeah. So pharma is the great example, because I'm sure you've also read a lot about the permissibility of generics.
Yeah.
So the pharmaceutical companies, and bear in mind, so I talk from both sides because I understand how much research and development goes into developing. Let's use pharma as the example.
Yeah.
An enormous amount of time and money goes into researching pharmaceutical patents, for instance.
Right.
And it's not 1 year, it's not 2 years, it's sometimes 10 years before a vaccine is discovered, or a certain medicine, for example, malaria tablets and malaria medication. So they need to recover the investment in those, let's call it 10 years. It's not always 10 years, but it's a significant amount.
You have a 2-year example right now.
Well, we do, rightly or wrongly. But let's not get into that debate. But so pharmaceuticals and in fact all inventors put time, money, and effort into the process, and they need to recoup this. And that's why you have, for example, royalty agreements. If you are allowing other pharmaceuticals and we'll use the pharmaceutical sector in this example. And that's why you have royalty agreements where a pharmaceutical will approach a manufacturer and say, we want to also launch that medication, but we can launch it under a generic name and under generic ingredient. So, and then of course the pharmaceuticals enter into license agreements, and there are royalty payments as a result of that. So just whilst I'm using this example, and Kaya, this is important for a scenario like yours, is that once you have got intellectual property, you are able to not only sell it, but you could also license it and get royalties out of it. It's a different commercial conversation, but many people, that's how they recoup the investment on protecting their IP, is that they license it to third parties to use. And they derive a financial benefit out of that use. Yeah. And Rahima, I think I do a lot of work in the automotive industry, and I do not work for the original equipment manufacturers, but I do work for the replacement part manufacturers and the small entrepreneurs trying to make a living out of in the manufacturing industry. That too has been kind of monopolized by OEMs who protect designs for all shapes, sizes of the cars, all the parts, accessories, etc. And we've, successfully challenged that in court, so that small players have got more of an opportunity to trade in that sector.
Right.
But there's no real that I can think of immediately. I mean, software is an interesting sector, because not all software is protectable by patent. And in fact, in South Africa, not at all. You have certain functionality that's protected, but in the US, for example, you can protect software. But in South Africa, you can't, but you can protect certain functional outcomes of software. So it's quite a complicated area.
Well,
yeah.
I'm sitting here thinking, if I'm developing software, I must go register it in the US and then apply global laws on that, because then I would have to comply as a South African, right?
Well, it depends where you protect. It depends where you protect and use.
That's another whole conversation.
It's another whole conversation. and please let's not get into it.
No, I'm not gonna
I'm going to confuse the audience, because it is a very technical area, and I think that startup entrepreneurs, they are not easily going to get involved in that. Software, absolutely they are, and technology, but the nuances of software protection from a patent perspective, it's a very technical area.
Right. Well, that tells me that entrepreneurs should be keeping their eyes open, right? And it's not just for startups. And I think a key thing about this discussion is that, you've got great ideas, protect them. They're tradable assets. Tradable assets walk a particular journey. And you as the entrepreneur have got to start becoming, it's a two-way responsibility, right? I'm hearing that entrepreneurs actually have to understand the journey that they want to walk in terms of the asset that they're trying to create and trade off, and understand the protection opportunities that are open to them in that space. The recommendation, obviously, that entrepreneurs try and operate in the local market first and establish, use of product and familiarity, and just in terms of being able to say it is a product or service or offering that the public has been engaging with, right? So being able to establish that it is their IP, and then the ability then to understand that, what you've also opened up for me is that whilst you are protecting it in one economy, if you are looking to walk the African trade agreement or trade area, the reality is that protection in South Africa opens you up. And I think that, Sister Jenny doesn't seem to be online, but part of the story that she has shared, and now this becomes a he said, she said, and so I'm hoping she comes in to tell her own story, is one of entrepreneurs coming into environments, creating stuff, and then, what we typically do as entrepreneurs is we try and find external markets. And so without telling a story, perhaps creating a scenario and you giving us insights as to what could happen differently. So a scenario here is, as an entrepreneur, for instance, I've got my brand name and we're still going to use Psychedelic, and I've registered it in South Africa, and I am invited to go on a trade mission. Isn't that exciting? Because on a trade mission, I'm with the whole country, I'm with delegates, and I go to, let's say, a Middle East or an Asian country, and I interact with business people in that country with my product. Now, if I've gone the patent route, then obviously I've patented it, but that's protected in South Africa, if I'm understanding.
Patents are global.
Patents are
Yeah,
global,
yes.
right? Okay.
Patents
So
are
I've got
global,
okay, but that's only for, so perhaps I haven't patented it, but I've been working with this product. I've
but
got
you've
this.
trademarked it. Say you've
I've
trademarked.
trademarked, let's say I've trademarked it, and then I've gone to the Middle East, because that's where, or Asia, that's where I have, those are two different places. But I'm meeting business people there who would like to work with me, and they take a hold of my product that I've created, the psychedelic vacuums, and we engage on how to do business. And as I come back home, they trademark my product. And because I hadn't actually gone the patenting route, they patent my product. And I come back home and I realize that now I am competing with somebody else who's got a patent, which is global, and a trademark, which covers a greater economic region. What recourse do I have to enforce an acknowledgement of ownership of that IP? And what recourse do I have in terms of being able to continuously trade with it, or am I now prohibited from trading on my own product?
So interestingly, and I do know a bit about Sister Jenny's story, and I'm not going to steal her thunder, but you'll remember that I said, let's talk about trademarks. So trademarks are territorial, meaning they have to be protected in the country in which you trade, operate, use. And in some countries, so for example, my trademark in South Africa is not going to help me to compete with a third person in, let's call it Asia. If they start using in China before I protect on the Chinese trademark register, China is a first to use country. And this is also a technical area. South Africa is also a first to use territory. So if I start using my psychedelic vacuums first, and I use it for 5 years, but I don't register it as a trademark, I just use it, I build up common law rights into that name, and it becomes a common law trademark. So if a third party suddenly decides, oh, she hasn't trademarked her psychedelic vacuums on the trademarks register, I'm going to quickly do it, that person will be stopped because of the strength of my common law trademark. In some jurisdictions, and in fact, here I think I'm wrong to say China is first to use. China is first to file, meaning no matter how long you use a trademark in China for, if you're not on the register, you are not protected.
So gone, really.
And I think this is what happened in Sister Jenny's story, is that even though she's very well known in this country, and she engaged with delegates in Asia, because she hadn't protected her trademark on the register, she has no rights. And that's very unfortunate, but I'm going to let Sister Jenny tell you about her own story. But there are many territories, and that's also why, Rehema, and I'm really not punting the use of lawyers here, I'm not using this opportunity to do it, but it is actually important to walk this road with an IP attorney, because we know the jurisdictions where it's a first to use or a first to file territory. So if you are doing business in Lagos, what are the rules in Lagos about trademarks? And you as an entrepreneur wouldn't necessarily know that. but you would be excited to engage with people who are interested in taking your product and offering into that territory. So it's really important before you even engage with those people to understand what the laws of their country are when it comes to IP. Yeah, yeah. So it is, and a lot of people don't know this. And so right at the beginning, I said, you don't know what you don't know, and it's not because you're not seasoned or you don't have the expertise. You just don't know what you don't know, and it's very important to walk a road with somebody who does know about IP. Just quickly to answer the question on the patents and patents being global. If I protect a patent in South Africa for a certain technology, before I protect, my lawyer is going to suggest that we do a novelty search, which means if you are trying to protect certain technology that exists anywhere else in the world, it's not novel and it's not new, so you can't protect it here. And that's what I mean by a global patent. So it's not that if you manage to get a patent in South Africa, it's worldwide, you're protected worldwide. It doesn't mean that, but it's the reverse. If you want to protect something, you need to search the global database to see if that technology exists anywhere else in the world. And people also don't understand that difference. So if I'm Kaya and I'm protecting my technology in South Africa, I want to go and trade in the States and talk to investors in the States and have partners in the States with my technology, then I should extend my patent from South Africa to the US so that I'm protected. Also a complicated area.
In terms of create your credibility profile locally. And I think the second area is understand the laws in the area that you're going into and the implications. And I mean, right? But I think what is unique is about, when we are also going on information sharing sessions. Again, the same thing about be careful what you're
Yes.
as we gear up, particularly as women in business on the continent, to participate in more trade exhibitions, trade fairs, as we share more about our products and services. So I think we should all have a lawyer on board and saying, what can I take and what should I hold back? What do I need to factor in? So a local IP lawyer. Is just any South African lawyer who practices IP, are they capable of providing the support that you need to protect you in other territories, or is this kind of IP protection from a legal perspective territorial in terms of who you should be considering to support or reflect or review your IP status and protection?
Yeah, so I'll explain how the landscape works. Is that we have, for example, I have got a very wide network all over the world where I protect clients' IP in over 80 countries. And in those countries, over the years, I have built up a really good network of IP professionals, all the IP lawyers. That's how we operate, because we don't know the laws in all of the territories. I mean, because I've been in practice so long, and I'm not going to give away my age, I have come to understand the IP laws in many territories.
Yeah.
But you still need to work through an agent who is authorized and validated in those territories to practice law. For example, I'm a South African admitted attorney. It does not entitle me to practice in the UK. And that's why I have to use a UK lawyer if I'm going to be protecting or enforcing my clients' trademarks. So you've almost got to have a post box in those territories. But in some territories, you need actual guidance on the IP laws in those countries. So IP lawyers generally in South Africa, and I know most of them, it's quite a small industry, and we have a very wide network all around the world. So that's why we are able to assist our clients to protect, overseas.
That's interesting. Sister Jenny, can you let us know if we can hear your sound? Okay, I think they're still testing with her. I have the interest.
Thank you.
We have got liftoff. Excellent, Sister Jenny. Can we just double check that we can hear you clearly?
I'm going to on Zoom and on Virtual.
Okay, please switch off your Virtuex so we just have you on Zoom. That will reduce your bandwidth. Please switch off your Virtuex. As they're sorting that out, I mean, part of the journey that I have walked is as a publisher, which was quite interesting, right? Because I've always seen that women's participation in the economy can be translated to women's IP, particularly hasn't been captured very well in terms of copyrighted material. So went the route of publishing, which is a thankless space. All those who publish, kudos to them, because I love reading, but it doesn't have much money. But what I found is in attempting to distribute around the continent, the different ways that IP is respected, just for lack of a better word. And I think publishing is one of those spaces where, you've produced a product, which is a book, but there's often things like photocopying those books is something that happens all the time, which in my understanding is an infringement of your copyright. But I've found that, for instance, some of the books we published have been selected as course material by universities, but they're not paying for those books. And in fact, students are just photocopying those books. So obviously the sales for the authors don't show very well. The income and revenue that then accrues to the author is non-existent, but those books are technically in circulation. Now, is this a function just of, and I think universities are notorious, university students, having been one myself,
Yeah.
for a notorious.
So that's very interesting because I know certainly at when I was at university, we were given designated sort of textbooks or works, and we were allowed to make photocopies of that, but not en masse. It was just for a paragraph that you were going to be tested on or whatever. But let's talk about the copyright respect between territories, because many territories, South Africa is one, is a member to the Berne Convention on Copyright, which really is a reciprocal respect of copyright. And so in your scenario, Rehema, if I live in the UK and you are in South Africa and you start making copies of the book I have published in the UK, I can actually take you on in South Africa, because of the Berne Convention allows me to protect my copyright that is in the UK from somebody in South Africa who is abusing my copyright in effect.
But in that scenario, are you taking on the university or the students?
Well, here's the thing, isn't it? Because, and would you take on all of those students?
Exactly.
You see, there becomes a practical element to enforcement as well. And you can put on as many disclaimers as you like on your work, your copyright straplines, but there is also a practical element to this. And that is, if I am a South African owner, an author, and I find a university in the UK who is doing what you describe, am I really going to litigate in pounds you think South African lawyers are expensive? Let me tell you that when you're paying in pounds, it's a whole different scenario. So you probably wouldn't enforce your rights, but inherently that is wrong and that is not allowed. So there's certain exceptions in copyright. So in copyright, if you are allowed to perhaps make one copy of a work for educational purposes, but that's for you. You can make a copy for you and you do with it what you want. But you cannot make copies en masse. You cannot sell copies and commercialize, because then you are detracting from the author's rights and income, as you said.
Yeah, and I guess that's the fundamental thing about IP, right? There's acknowledging that it's there, but it's also the cost of protecting it,
Yeah.
and the cost of just the process. First of all, there's a long process to ensure that it is an asset, a tradable asset, but then protecting it once your rights of use or the rights of use have been infringed by another party.
Mm.
Which is quite challenging. And I think then that the cost of doing business needs to factor that in, right? I think what I get from this
Absolutely.
conversation is that the onus of and the duty lies on the entrepreneur to protect that asset. If it's deemed an asset, due protection of that asset. And I guess then for me then also comes into, I wonder if you can insure it in that way. Can you insure your IP?
Well, you can't. Your insurance is your protection, and then once you've protected IP, you must enforce it. So don't just let third parties use it and you don't take them on. And I say that with a lot of appreciation that a lot of people don't have the money to litigate, but it's really important. If you're going to spend the time, money, and effort to protect IP, then you must follow through and enforce it. Don't, be vigilant, be very vigilant in your own market of what your competitors are doing, whether they are springboarding off your efforts, and whether they are unlawfully competing with you by using your IP in some shape or form.
Wow, that's a beautiful new lens to put onto it. So once you've got your IP, don't sit on your laurels and say it's mine. But the
Correct.
vigilance and as I guess you do this market scan all the time as a business person, who else is here? What are they doing?
Yeah.
But this notion of enforcing, does it create a precedent when you don't enforce it with one and then the other? Does that
Yeah, it dilutes your rights. So if you just sit back, there is a principle in trademark law called acquiescence, and it's a very fancy word for allowing. So if you allow a third party to use your intellectual property in whatever shape or form, and you don't take them on about it, or you don't try and stop them, eventually you will lose your rights to enforce anything against them. So there are a lot of consequences to not protect, not enforcing your rights.
Yeah.
And it's difficult to keep tabs on what everyone else is doing because you're so busy in your bubble trying to make money, trying to service your customers and make your clients happy. But it's really advisable to keep your eyes open and see what your competitors are doing, because often if you are making a success of your business or your product or whatever your offering is, you can be very sure that your competitors are going to try and leverage off you in some way because you've done all the work. And so, what we do for our clients, so our trademark clients, I have my whole team. They know when they go to a shop, when they stop at a robot, when they are walking in a market, I tell them, take all the flyers. None of us want that stuff. None of us want that stuff, but take it, because it's on those pamphlets and flyers that you see infringement of your client's trademarks. And when you go shopping, my husband really does not like shopping with me because I forget what I need to buy because I'm so busy looking at colors and designs and logos to see if any of my clients' trademarks are being infringed.
Oh, wow.
But that's how vigilant you have to be, because you won't believe what goes through the cracks in the market.
Oh, wow. Vigilance.
Yeah.
Oh, sorry, Jane, we're taking up so much of your time, but this is such a wonderful conversation. I think, as you can see, we're going to have a number of these in the series, particularly as they start talking about this at at a policy level for the AFCTA, but just understanding as we start discussing what is the entrepreneur's perspective on this. Again, I think I'm very curious as to how that pans out, how my protection in one territory can be extrapolated to more territories as a matter of interest, but also what that means in comparison with other territories. So if we have an agreement that covers Africa, how does it coexist with agreements that perhaps the EU has and other agreements that globally they have around trademark law or not trademark, but IP protection? And I think that the more we are au fait with the changes, with the discussions, the more we can understand as entrepreneurs how they impact us directly. So thank you so much for joining us on this part. I hope we can get Sister Jenny on. I'm just going to ask my team if they can get Sister Jenny on. If not, we're going to take like a 3-minute break. I think I'm going to ask that they play a video as we just try to get Sister Jenny back on. Thank you very much.
Thanks, Rehema.
Right. Okay. So if you have got any questions about trade law and IP and how you can factor this in as you are looking at or you are currently doing business on the continent or globally, do tune into our YouTube channel. I think the link is on, will be put into the chat or also shared on our social media platforms. Do engage us, send an email. If you would like to share what other topics you would like us to be presenting as we do the AFCTA series, please do share those with us. Thank you.
Fastest growing economies in the world. Asia? No, it's Africa.
Historic deal has been signed in the Rwandan capital, Kigali. Many African heads of state have agreed on a treaty that aims.
Pardon?
This would
I'm
make
only
the
adding
region
myself,
the
no one
largest
else is
free trade
adding.
area in the world.
We can only gain dynamic comparative advantage if we trade more with ourselves. If we don't make it possible for us to begin to produce the light manufacturers that China will soon stop producing, we will find that they're looking for other countries to start.
This is the land, young people. This is a land with great resources of inspiring people. I mean, these people are good.
When I look at it, it's actually the women that kept the economies of Africa actually going. Most of the businesses you find in Africa today, 80–90% of them are the way financial markets work. We've got to trust women businesses better. We have to support them with technical assistance, but we have to let them grow. Because when Africa gets the
When Africa gets the story of its development right, and rather when Africa gets the story of its women right, it'll get the story of its development right. No truer words have been spoken. But Africa's development requires women at the heart of their economies. I'm going to introduce a speaker now that we've been trying to get on for a while, Sister Jenny. I think she's finally come on board, and she's going to be sharing her story. Without further ado, because you've been having challenges. Sister Jenny,
Can you
please
put
share
my
your
screen
story.
on? I can't see myself.
Yes, your screen is on, Sister Jenny. Please share your story.
My presentation. Hi, everybody. I'm so sorry about this mix-up today, but we will come right. Can you see my screen? There it is. Okay, here goes. Should I start from the beginning? So I'm a very passionate entrepreneur. Okay, so I became a nurse because I really couldn't bear to see people suffer. And then after 18 years in the hospital, I decided to develop a cream specifically to help diabetics and people who had problems with their skin. And I registered in 1992, or started in 1992 and registered in 2000. So these are just all the safety and the clinical trials that I've done. And I created a cream that works in 1 minute on very dry skin. But the same cream, which is actually a hand cream and a foot cream, also heals diabetic ulcers and wounds and burns. It's now proudly South African. It's got a huge target market. And I've been recognized as one of the leading inventors in the world for natural products, along in an article along with Elon Musk, Mark Shuttleworth, and the 4 Nobel Prize winners. This is what my cream does literally in 1 minute. And this is clinically proven in a 30-page cream. Can you hear her talking? She interviewed me about the book, about this book of women inventors and the 7%. They've written a whole chapter about me in this book. So I've also been recognized by the Quadriplegic Association because my creams are really amazing, even for quadriplegics and anybody with spinal cord injuries. I also won numerous awards, but one of them was the Fair Lady Best South African Health Product. I got recognized by the United Nations in the annual report of the United Nations in Protect, and I've also been on the cover of numerous magazines. And then I started registering my trademarks as early as 1994. I am on the register. And also in 2013, when I changed the logo, which was specifically designed for me by the SABS Design School, paid for by CEDA. I registered the logo, the trademarks, all the names, Sister Jenny, Gentle Touch, and Gentle Healing. In 2018, I was recognized as one of the top 40 national gazelles. Actually, along with Kaya, she was also recognized. And the National Gazelles took me, the Minister of Small Business took me to China and told me about it 4 days before. And just before we went to the exhibition, they said to us, just be careful, they might steal your brands. So watch this.
Thank you for bringing your products to China, and thanks for your love for all the people in health.
So I got interviewed on TV in China because everybody was mad about my products. I managed to convince the exhibition host. He brought me all the media, and there were lots of interviews. And the specific reason was because of this diabetic foot. That was actually half this foot was cut off, all the gangrene and all the sepsis. And 8 weeks later, the lady had her foot back. And this caused quite a sensation, and this proved it was a unique product. So this man came to, somebody at the exhibition saw me, and he came to South Africa, and he said he wants to be my agent, and he bought a whole lot of stock from me. And 1 day later, literally 1 day later, which I didn't know about, he registered the trademarks in China. He saw on my shop, Sister Jenny, Gentle Touch, and Gentle Healing, and he registered all the names 1 day later. This is an interview he did in China on the South African Mall, showing that they are going to sell South African products, promoting small business. So they're basically promoting small businesses and something to do with the Belt and Road. They're helping small businesses from South Africa sell in China. They've got agents, B2B, and they're doing this wonderful work to help South Africa and China, so-called, if you don't mind me saying so. And he asked me for, he said he doesn't want sole agents, he just wants permission to sell my product. Then he started asking for the power of attorney, and my father taught me never give anyone the power of attorney, because as soon as he said he wants power of attorney, I knew that without my permission, he could register the trademark in China. And for that reason, I specifically did not give him the power of attorney. We were working together, or so I thought. He was buying the cream and selling it in China. And this lady he's working with him. She's part of she also registered the trademark. And then I noticed they were doing funny things like saying, sunscreen is free in China and advertising my baby cream. I only found out afterwards when I found out they registered the product, that they registered baby sunscreen. They registered my cream to make baby sunscreen. So a year later, I got a letter from China from a very kind IP lawyer who said they are using the identical trademark logo, everything identical to you, and you've got to protect your brand. So I was very upset, and it was Sister Jenny, Gentle Healing, and Gentle Touch. I was, by the grace of God, taken back to China by the South African government. And before that, I did research, and I found they hadn't bought my product for about a year. They said it wasn't selling, but they were selling my products on a huge international trade market, kind of like the Rand show 10 times, selling my product with my logo, all my claims, the HIV sores, the rashes, the bed sores. Here I am interviewed on the screen in China. I was interviewed at the exhibition. I mean, I had a whole presentation on the screen. They made so many videos about me. Sorry, my throat's a bit funny. You'll see Nelson Mandela in the background. There was about 8 or 9 interviews. And then I was taken back to China. I appealed to this very kind man who was the head of the exhibition. His name's Mr. He. And he had signed a contract with Lindiwe Zulu, excuse me, the year before. Excuse me. And so he had agreed to represent, he got a lawyer for me to invalidate, first to oppose the trademark registration in China. Excuse me. And he paid a lawyer to represent me, which must have cost him a lot of money, because he felt I had such a unique product, and I was a world famous brand. I never showed you pictures of me in the Oprah magazine and various other. I can show you how famous I am worldwide, but you don't need to hear all of that today. So after we had a whole story, we did the opposition. And I must tell you, the Chinese embassy also said to me that they would submit my opposition, but that failed. And after all the evidence, we still failed. They still gave the trademark to the Chinese guy. And then they found out they made a mistake. They forgot to translate my ID into Chinese. So the lawyer again agreed to invalidate the trademark, because now he says it was registered by mistake, because it was their mistake. And he gave them more information to invalidate the trademark. But unfortunately, we just recently got a letter saying the invalidation also failed. First, it sounded like they said we won the case, but then it said we didn't sign a contract with them, and we actually gave them permission to be our agents. So they knew they were our agents. They did agree to be our agents. And they also said the reasons we failed, that we didn't allow them to be our agents, which we did. And they also said that we hadn't been performing in China, which I had a website in Chinese since 2011. So somewhere something went wrong. I definitely showed, I was in China from 2011. I had a presence in China, and I had all those interviews. My one interview was so famous, I got 500,000 hits. And according to the Chinese embassy, this man did everything right, and he did it all legal, and it now belongs, the trademark in China belongs to him. So I'm a very passionate person, as I told you. I've started the Burn Foundation. I've had huge recognition. I've worked like an absolute dog for 29 years. I cannot allow anybody to take what belongs to me. This is not just a, excuse me saying, but a Chanel handbag. You can't just make a product, call it something, you know, with my name and make a fake product, because no one can do what, look at this burn of a child who was in ICU for 2 weeks and 7 days after using the cream got his face back. I have a product that's unique in the world, that's an international brand, that's won all these awards. I was taken by the South African government to China. I'm a woman, I'm a small business. I need help, and I'm appealing after 29 years. I'm saying to everyone, you have to find a solution to this African Free Trade Agreement. Everybody needs protection. There has to be a way that small business can cope, because I had the lawyers paid for by the Chinese exhibition host, which is very unusual. I'm sure not one person here can say, because everyone says, oh, it happens all the time to everyone. No one can say the exhibition host paid a lawyer to represent them. There's no one who can say that in the world, I'm sure. No one can say that they've had the recognition to this degree, that they have a product that heals third-degree burns that can do. I have the head of a huge hospital, I'm not going to mention the name, who sells my cream in his practice and uses it on his burn patients. But the hospital doesn't use the cream. But this man sells it for double the price. This doctor, plastic surgeon, sells my cream in his practice and uses it on every single burn patient. And this is my contacts. I'm very passionate. I cannot allow China to walk off with my 29 years of hard work, my very unbelievable invention. I know the value of my business. I'm not giving up. I sound like I said I was going to be humble, but it's very hard to be humble under these circumstances. I deserve to be helped. I'm a small business and I deserve to be helped. And I want the law to be changed. So somebody like me, because a well-known brand, according to the Paris Convention, should be protected even if I hadn't registered. And I've got first usage and I was on the register. So please, whoever's out there who can help Sister Jenny, it's absolutely critical that you do find a way to help me, because people's lives depend on this. There's no one else who can heal the third-degree burns. There just isn't solutions out there that my cream has helped things that nothing else on this earth has helped. And so, excuse me for being so passionate, so determined. And Rehema knows me when I did my TED talk. There's just no way I'm giving up. I can't. This is my whole life, but it's not only my life. It's the life of little children who deserve to have their faces healed, who don't want to be scarred for life because China thinks they can make a fake product. And I'm not criticizing any country, but I am saying they cannot take what belongs to me. This is my invention, and I created it. It's 29 years, and I deserve to have some financial benefit from it. Thank you, everyone, for your patience to wait to hear my story. I really, really appreciate it. Thank you, Rehema and Womanomics, for this wonderful opportunity. I thank you.
Thank you so much, Sister Jenny. I'm so glad you finally managed to tell your story. You know, I'm one who firmly believes in the power of telling our stories. It helps us to provide context. It helps us to share experiences. Most importantly, it helps us to get insights as to what we can do differently, how we can engage differently, and what power is and knowledge is vested in those stories, or what actions we can take. Sarah Jane, see why we brought you to this conversation. We've got passionate entrepreneurs who feel hard done by, right? But there's a difference between feeling hard done by and what the law prescribes and what we can do and what claims we can make, how we can make those claims. And I know she's coming on and off, but I think I'm very glad she's been able to tell her story, share the context of her story. There's a number of times where she refers to China, but I don't think that China is the defendant, clearly. I think it's hard to take a nation to court, but I think it's easier to take business people who who do some interesting stuff. I'm going to use the word interesting because I don't know what legally one can say, alleged or, or rightfully said, or I don't know the legal terms around this. That's why you're here and part of this conversation. Having heard Sister Jenny's story in her own words, without us putting in any form of filter, which captures not just her passion, her dedication, and her perspective, most importantly, help temper us in terms of the perspective versus the law versus the truth, in terms of the law and versus what is actually possible. Can you frame that for us?
Sure. That you probably are the only person in the world that a government delegate has taken you to another country and trying to fight your cause for you. So you are very beneficial on that score. What and her trademark and her are well known. So this is not in my slides because 100% correct in that our Trademarks Act and in fact many territories who subscribe to the Paris Convention and of course the onus of proof to prove that you are well known and that your trademark has become well known is very high. And from what Sister Jenny know about her, many people know about her product around the world. So just on that information and high level, I would venture to suggest that she is well known. I mentioned earlier, the Paris Convention allows reciprocal enforcement when it comes to a well-known trademark. That's where let's call it the aggravating situation has happened. Now, it comes down again and has actually compromised her rights. And it's not China, but it's the Chinese registry. And you would have to take the Chinese registry on, so not the businessman, because you're just going to get another businessman like that who might want to leverage off you and your product. It's actually the registry that needs to be taken on. But here again, whenever we enforce our rights, there is a cost. So I think it sounds to me, Sister Jenny, like you have a very loyal following in China and you have loyal support. You have a good network there. And I'm not sure if they've ever recommended to you to take on the Chinese registry for their ill-informed decision on this matter.
They actually have. But they gave me 1 month to appeal, but they also did not translate it into English. And no one told me that I had 1 month to appeal. And they also asked me for so much money that I couldn't afford to appeal.
Yeah, you see, and this is where justice is not carried out, is that no matter how well you're protected, if you don't have the money to enforce your rights, you're between a rock and a hard place. And it's very unfortunate that. But your story, sorry, carry on.
I said, I won't give up. I think the media, it's very strange that the media hasn't taken my story because they think everybody has the same problem with China, but this is a very different story. And I think the media should now come on board and feature my story internationally so that eventually somebody who does have the money will take on the registry. As you say, it's not China themselves, but the registry.
Yeah, and those are the different avenues that you pursue. You know, social media is very powerful these days. The power of social media, they call it, is, you know, you could get a lot of support from crowdfunding for people who are passionate about this as well. But I do want to touch on another interesting aspect that you raise, and I alluded to it earlier, is that when you start out, gather as much evidence as possible and keep all evidence of what you do with your business, product, invention, offering. Because in order to prove, for example, well-knownness, or to prove your rights in a common law trademark if you haven't registered it, it's really important to go back in time to when you first started. And it seems, Sister Jenny, you have done just that. You have kept recordings and articles, and you have published records, which is fantastic. I mean, that is a very strong piece of advice, is keep everything and anything about what you do with your business.
But
Rahim, I can see that you've got a question.
Is that obvious? Yeah. I think, you know, it's almost heartbreaking, right? That you can lose out on, but she raises important elements, right? Which is understanding the environment that you're going into. And if you're going to try and seek protection, language is a key thing. Across the continent alone, many of the countries have different languages, and not understanding the language could prejudice you. So I would imagine that even as you're trying to exercise your rights, and you don't conform to their requirements, notwithstanding whatever your circumstances may be, the system would be prejudiced against you, because they're not actually doing you a favor. They've got a process that they follow, which, I mean, it's almost heartbreaking, right? And to raise the question of being famous, right? What does fame have to do with it, and where does the fame need to be acknowledged? So if you're famous in one territory and not in another, what does that count for? Because I think this goes back to the question earlier of if it's registered in a place, then, you know, does it matter that it exists in another? I think we've had other examples of this. I think it was the what do you call it? The pizza guys that set up here that had a particular name, similar, not quite the same, but there was a pizza franchise that had the same. Was it Romans or something like that?
Was it not Debonair's?
Was it Debonair's or Caesar's or something, like one of the pizza?
Yeah,
it was Caesar's that became
It
Roman.
was Caesar's, right? That became Romans, right? So who can exercise rights of use, or is it because of how they have protected in the territories that they've gone through to protect their IP? That sounds daunting for entrepreneurs.
Yeah,
well, not your large business.
It is. I just want to caution everybody that the general principle is that if you travel, for example, and I'm excluding well-known trademarks, for example, brands that are recognized around the globe, Nike, Victoria's Secret, Chanel, McDonald's, Starbucks, I'm excluding, because those are truly well-known brands. Everybody around the world knows about those brands, so they are well-known trademarks. But if I go on a trip to Florida and I find a unique jar, and it's called this amazing name, and I love it, and I want to take it back to South Africa, and I also want to make jars under that name, there is nothing prohibiting me from that, because of what I said earlier about trademarks being territorial. But from this conversation is excluded well-known trademarks. You cannot copy a well-known trademark. Sister Jenny, and I'm not trying to interrogate your case, or because I don't know all the facts.
Disclaimer: this does not become technical advice.
This is not legal advice. But it seems to me that you are the famous one, and your trademark has become very well known and popular here, and you, the individual, have become famous. And that
I've become famous around the world. I've been taken to China, Malaysia, Japan, Saudi Arabia, and America
individually. And so I think that that's an important distinguisher here, is that, and it leads to everything we've been talking about in this session, is that before you go into a territory, make sure that your product name or your service offering or whatever, make sure you protect it on a register before you engage with anybody, because that's really critical. Otherwise, you have to go through the pain that Sister Jenny is going through, and you have to almost prove your well-knownness and your fame. Because I mean, rightly or wrongly, I think the Chinese registry have made a fundamental error in this decision, from the facts that you tell me, and that's why I say I think your right of recourse lies against them, and not necessarily the businessman. But be that as it may, it's very important that before you engage in another territory, you might be well known in South Africa, and you might have a large following of people who know you around the world. But if you are not protected on those registers, and you can't obviously protect on every register, and that's why you need to isolate your core markets where you want to be. But that is really important advice.
Wow, I'm here. My eyes are wide open. We had been invited to a trade mission to West Africa over the last week, and because of COVID, we couldn't go. And you are saying that by not going, I've probably protected my company, because we are not registered in those territories. This particular company is not registered in those territories. It does produce products. It does, we're obviously trying to grow the brand here, but it does produce products which you can replicate in another market. And if we're trying to do cross-border trade, intra-Africa trade, we might have been compromised now trying to enter territories with this name and identity and product offering, which we've taken unknowingly, becomes public in that space, but not protected.
Yeah, and Rahima, especially when you start engaging with distributors, for example, and I do a lot of work on this topic, where distributors, you don't tie them up sufficiently in an agreement and make it clear to them that the intellectual property is yours. They, in their territory, then register it, and it may be a first to file territory. So the fight that you will then have to have, and the cost to get your trademark back, because you engaged commercially with that individual, it's very difficult. And so just beware of who you talk to and who has access to your brand.
I mean, that's another thing. I mean, you're saying, if I'm hearing you correctly, you've clearly touched me on my studio. You're saying,
good. That was the purpose of this, right?
Because I mean, the one way we can see, and when I say we, those who are currently doing cross-border business and are looking to expand areas of cross-border business, is obviously this understanding that a lot of the business within countries is more nationalist, right? And therefore requires that registration of companies, etc., happens with the local. So if part of the journey that you've walked is to set up a distributor agreement with a local, but you haven't taken time to protect your IP in terms of the trademark in that territory, your distributor, if I'm hearing you correctly, register the product that they are distributing in that territory, and you won't have protection. Say if that particular distribution license ends, you would struggle to put that same product in that market.
Absolutely. Absolutely. It happens all the time. And I'm not saying all distributors, but it happens all the time.
That's pure witchcraft.
It is witchcraft. Sorry, I just want to point out that my battery is running low, so I may have to just SMS somebody to just bring me a battery charger.
That's totally fine. I hear, Sarah Jane, that there's a question. I'm just going to bring you back on so that the audience can hear your question, Sister Jenny. Please ask your question. If she's looking down, she's texting somebody to get her a battery.
No, don't worry. I'll be looking up.
I'm not looking down. I'm not looking down. Can you hear me?
Yes, we can hear you clearly.
Okay, I'm going to talk even if you can't see me. So first of all, I kept a trade secret. I never registered the patent. And 29 years now, I still have the trade secret. That was for me the best way to do this, so that nobody could. I've still got something of very high value, and that's why I'm protecting it with my life. But it's quite difficult, you know. I feel that what's the point of the government taking us anywhere if somebody can swallow us up? Because small businesses do not have that 10,000 Rand. Or in my case, it would be, for trademarks, it would be 40,000 Rand. And in China, it's not 40,000 Rand. It's 3,000 yuan per product, which is
$3,000.
like 250. It's like 250,000 Rand.
Yes.
That's what it would have cost me to do that opposition to take on the trademark office, the what do you call the trademark registrar. That's what they wanted, 250,000 Rand. Now, most small businesses cannot afford that, and I'm sorry, I couldn't. So it's so easy. I think that before a country takes you anywhere, before a government takes you anywhere, they have to protect you, or they have to sign an agreement with the country that should something happen, they will fight on your behalf.
Well, yeah.
And there has to be some kind of trademark agreement between the countries to protect everyone.
Yeah, but unfortunately, and you know, Sister Jenny, there are many trade agreements between territories on intellectual property. We have a lot of cooperation treaties with many countries in the world. And unfortunately, again, it's, you know, no one's going to protect a person's rights for free. And that's where the rub is here, is that, you know, governments simply don't fight on behalf of citizens. So you have your agreements in place.
That is unacceptable, because, you know, they put you in a situation, then they have to fight for you. Especially when you have something.
The reality is that they're not going to. The reality is.
But if you have something that can change people's lives, sorry to interrupt. If you have something unique that can change people's lives, that can literally make a difference to the life or death of someone, they have to consider that. They have to take that into account. They can't just, I mean, why did I get interviewed on TV in China in the first place? Because the product was so unusual. And why did the exhibition host even consider paying my lawsuit? Not because he loved the look on my face, but because he saw my product was different. And he felt that China needed a product like that.
So I'm interested to know why he didn't foot the bill for your opposition.
Because he paid quite a lot of money for the other two cases.
Yeah, you see, it unfortunately, it always comes down to a price. Someone has to foot the bill, and a government is not going to do that. I will applaud you if you take on the government to try and get them to do this, but the reality is that a government is not going to, unless there is a pandemic situation, let's say, and you know, the government hasn't even come to the aid of the PPE distributors who have been the victim of corruption, and so that's it's a ethereal conversation.
Yeah.
Wow. I'm not criticizing our government, because they took me to China twice. But I feel that they've got to hold my hand to win this case. They have to show that I am a famous brand, and they took me to so many countries, not just one country. And I've been highlighted by the UN and numerous, I've lost count. They have to now say this product is of value to our country. If they're not going to fight for me, they must put me in the media of CNN, SABC, whatever, and tell my story and help me get the funds that I need to fight this.
Yeah.
Because this is a, I want to set a precedent that small businesses in my situation with a unique product that can really change lives, it's a social innovation. This kind of product needs to be protected. And it needs to be supported, not only protected, but also supported. And I just feel you can't just throw me to the wolves.
I'm hearing that, right, Sister Jenny, and I think that, you know, I always say it's by sharing our stories that we are able to, you know, start the start the journey towards champions to effect the change of the things that we think require greater attention. What you've raised here quite clearly is the need for advocacy on support. I think what you've raised very clearly, which must be taken up, is what are the responsibilities on these government trade missions? What is the protection of entrepreneurs? What I'm hearing Sarah Jen say is that as a business person, the onus of protection lies with the generator of the idea. And if the generator of the idea hasn't done due work in protecting that, they are left vulnerable and they are left with bearing the brunt of taking up the fight to get any form of recourse. And whilst it might not be an ideal scenario, it sounds that, what we've brought her on board is to say, what's the status of the law? Which is not always what would we like for the situation to be. And I think that's a telling element, right? And that's what we're trying to get clarity. I, for one, have just been enlightened in this conversation in terms of, before I think of doing business on the continent. Unfortunately, it's taken stories of yourself, it's taken stories of Kaya to illuminate for some of us where some of the gaps are, where the assumptions that we've made, where we've assumed protection, or where we've relied on protection, where it doesn't exist in terms of what the tenets of the law practically allow us to be protected for in the ways that would be ideal for us. I think for me then, in terms of Sarah Jane, so thank you so much, Sister Jenny. Aluta, unfortunately, it's one of those places, and I hate having to say the struggle continues, but conscious of the time that we have for this conversation, I think this is one platform where we can share your story. This is one platform where we can highlight the flaws, the rationales, and as well as the assumptions that we've made, but practically what the law stands. I think, Sarah Jane, a couple of questions that have come in for you is to ask the question, being that this is such an expensive process and being in the field of invoicing for this kind of journey, are you aware of parties who or funds that have set aside or that women can contact to protect their journey or to finance the protection of their journey? Are you aware of any such? Is this an opportunity area for advocates?
I think it's definitely an opportunity. And I do know that there are investor forums. Again, and I really don't want to, I'm trying not to be cynical, but I'm in this, so I also need to be realistic when I answer this. I think it is a great opportunity. But remember, it is like these investment houses who fund businesses. All investors on that level will want a piece of the action. And so either your IP will become diluted because you'll have to share it. You'll have to assign a portion of your IP for them to assist you financially. I'm not sure if you're aware, there are certain litigation funding investors that were quite a generic topic overseas. There are many litigation funding houses. It was an unknown in South Africa, but in the last 2 years, it has actually taken off here quite successfully. And it is mainly around patent litigation. So if the investors think that you have got a viable patent that is worth litigating for and protecting, they will fund your litigation. But the upshot of that for them is that they will then get rights to those patents. And then you will have to license them back from them in order to have paid for the money that they invested to litigate and protect it. So there are those organizations.
It doesn't make sense. No, it doesn't make sense.
Can I also tell you something? That I was totally unaware that trademarks were territorial.
Really?
I thought when I registered my trademark that I was protected. I didn't know that was only in South Africa.
Yes,
no one ever told me
many people don't know this. And you know, for us IP lawyers, we can't turn around and say, "What, did you not know that?" Because you don't know what you don't know. And I have an interesting question on the side of my screen that I do want to answer because it's relevant. And it said, is there a central agency of IP registration for the African continent? I have dealt with this specifically in this guide that I've given you. is that there is no such thing as an international registration from where we sit in South Africa. If you live in the United States of America, there is an international registration that designates a number of countries in the world. But that is only if you're a US citizen. In South Africa, and you're wanting to go into your African continent, there are two national filings, let's say, or two regional filings. One is called a REPO, that is the African Regional Intellectual Property Organization. It's all in the slides, so you don't really need to take notes. And that is a multi-territory application that you file, and it covers approximately 8 to 10 countries. I have listed them for you. And those are the English-speaking African countries. So you can do a multi-application for that. And then there is another system called ORP, which is simply the African Intellectual Property Office. It's very similar, but it's for French-speaking African territories. And that also has a number of states designated in that application. And that really is the only multi-territory filing that we have access to. For many years, our registry has been talking about signing up to the Madrid Protocol, which would enable us to do an international registration. It's been coming for many years. We've had many discussions with the registry on this as IP attorneys. But as yet, South Africa has not acceded to the Madrid Protocol. So I think it's coming.
What is the problem?
I think there is a lot of resistance from many camps in government about this, because our registry makes a lot of money from national filings, and that is one. I think revenue is a big consideration for our country because we don't want to lose that revenue. And I think there are other aspects, such as, are we ready enough to enforce an international registration? Because international registrations have very different enforcement mechanisms, and your domestic law has to tie in with those agreements, and that can be fundamentally different. So it's very difficult to align the two. Those are just some of the issues that I think are holding the Madrid Protocol up. But that also is a conversation for another day.
Wow, I'm actually shocked. Thank you so much. I mean, I'm quite shocked. We always said that this conversation is going to take about 2 hours, 2.5 hours tops. And for the third time, it's like it's a 3-hour conversation when we start to unpack. And I mean, that tells us why we have this masterclass. That tells us why these conversations that we're curating around how to protect us doing business on the continent, how to get ready. Because we keep talking about the fact that AFCFTA is a stimulus package for Africans, that the Continental Agreement is actually, the starting point of us being able to collaborate more. But the questions that we have to ask and answer as South African people in business is, are we actually ready? Have we factored in? And this is not just about South Africans going to do business on the continent, but also for our partners who are looking to do business with us, to factor in the real, you talk about the nuts and bolts, the crossing the I, the dotting the I's and crossing the T's before you go out and leave yourself vulnerable. And I think this one is a question that's asking for your opinion. In your opinion, can the AFCFTA and accelerated intra-Africa trade begin in earnest if the protocol on intellectual property rights, which is currently in phase 2, which is in phase 2, not yet negotiated and finalized? Practically, should we be going ahead? And should trade begin in earnest as entrepreneurs, given some of the concerns around IP that you've seen? What should we be factoring in or thinking of?
So I actually think it's a commendable engagement or cooperation agreement on one level. I really do. And I think that our territories, our neighboring territories, and South Africa ourselves are ready for it. And in fact, we need it, especially after the devastation of COVID. that's brought upon our economies. We absolutely need it, and whether we're ready or not, I think it must be pursued. But on the intellectual property front, one is always going to have to acknowledge that that is not going to alleviate one's responsibility to protect one's IP in terms of domestic law. Even the repo filing that I talk about, we are experiencing a lot of difficulty in enforcement under that regime, simply because those territories have not incorporated international law into their domestic law. So our clients are finding, whilst we want to really motivate to repo filings because we think it's the right thing for the territory, the African continent, it's difficult because when it comes to the enforcement of those rights, our clients are saying, well, why did we even bother with such a filing? Because we can't enforce our rights under that protocol. Wow. So it's those issues that need a lot of workshopping and a lot of momentum to come right. And you know, these things always take a lot of time, and there are a lot of stakeholders involved.
Understandably. Thank you so much for that. I'm going to ask for Kaya to be queued in as we, thank you so much. Kaya is there, nice and bright, as we wrap up this session. There's been so many highlights that have been shared with us, so many takeaways that have really, it's almost like, you know, the first principles of trade, buyer beware, is really about entrepreneur be aware, right? As you engage in these spaces. But I think that what for me is illuminated, that this is not just a conversation for entrepreneurs who are looking to do business on the continent, but just entrepreneurs in terms of being idea generators and being innovators, being those who are bringing in something that didn't exist before. How do you manage and protect your asset? And I think that the word asset becomes quite important, because in the same way you would protect your home, you have to do the same kind of effort to protect your intellectual property, where you're trading it, how you're trading with it, how you're interacting with it, how you're sharing it and occupying that space that you've created as your sanctuary, or whether it's something that is commercially out there for many people to be using in a particular way. Lots of food for thought. Great thanks to all the panelists that have come on board. I'm going to ask if you've got any final words to share with the audience. What are your last words? And I think that Sarah Jane, in the context of the work that you've done with women, perhaps the one highlight you'd think that we should stay with. Kaya, with the experience that you had being an entrepreneur and being burnt on this wonderful continent of ours, what last words? And also to you, Sister Jenny, in the context of doing business and taking on a whole Chinese registry. Wow. What are the final words that you can share with our audience? A few sentences.
I just wanted to say thank you, first of all, for just today's session. Sarah Jane, it's been an amazing. You're so right, Rehema. You know, the AFCTA is really, it presents such a huge opportunity for us as entrepreneurs, you know, going out and doing business in the rest of the within the continent. And there's a term that comes out every time, you know, besides just being only South African, but there's a term that they say TIA, which is and they often caution me, be like, you know what, don't be South African here, and this is Africa, Jack. So as much as there are opportunities for us to work in the continent, and I mean, it happened here at home. So we need to really be vigilant, clean our house, and make sure that we've got our things in order. That's all I have to say.
Thank you so much. This is Africa, babes. This is Africa. Gotta catch a wink.
You gotta be.
And on that note, my last food for thought. I hope I haven't been typical lawyer, which I always bring a negative side to things. But I want to say, when it comes to IP, you know, go forth and create. but protect, because that's what's going to set you apart in getting ahead. You know, we're women, we are creative, and we mustn't stop being creative, but protect along the way.
I see a comment in the chat line. Africa is not for sissies. You better be brave. You better be
100%. 100%.
We know that more than most in the world.
And Africa is made up of amazing, strong women, and I use that word very carefully and cautiously. Sister Jenny has gone off the line again, but thank you to all of you for making time, sharing your time, your knowledge, your intellectual capital with us so generously over this time. I will be playing the presentation that Sarah Jane has shared with us at the end of this discussion, so please don't feel like you've missed out. Sister, we will be playing it as a presentation so that you do get to see the content and you don't miss out on what she keeps referring to that in the presentation. For everybody who signed into this chat, we will also be sending to you via email, so expect to have it in your inboxes. We do share all our content with each speaker, which each participant freely, because we are looking to create economic highways, and the first path of economic highways is knowledge. Do register for the next session, which is scheduled for January, late January, and we'll be talking about financing the free trade movement, or rather financing trade across borders. And we're excited to be bringing you that late in January. But for now, thank you to everybody who's made this possible. This translates to time, this translates to money. And so we acknowledge and appreciate that you've gifted us the beauty of having both of those from all of you. So from us, the Womanomics team, to all of you who've joined us, thank you for joining us. We also have each of our sessions played on YouTube. So do subscribe to our YouTube channel, Womanomics Africa on YouTube, and each of our sessions will be rebroadcast there each time we have a session. So session 1 and session 2 and session 3 will be available on YouTube as from tomorrow. Thank you to everybody for joining us. We look forward to having you and hosting you very, very soon, and that's as soon as next year when we do the trade session. For now, I'm going to leave you with our presentation, which is really taking you through the presentation that Sarah Jane had shared with us. Look forward to tuning in. Awesome.